What's up, guys? Colton Richardson here. So in the Amber Heard insurance lawsuit, they have filed a joint status report. The court has. And we'll break that down right here and we'll look at it right now. So what a joint scheduling order report is just where the court can issue a timeline for the case. And they break down a little more in this one where the parties are at and what they're expected to do and argue because of the issues that are in this case. In other cases, it's usually not this long for a joint scheduling report, but in this case, because of the issues, it's a little longer. So we'll break it down right now. As you can see, the two cases have been consolidated only for pretrial purposes. Pursuant to the court's October 21st, 2022 order on traveler's motion, plaintiff and counter-defendant travelers, counterclaim and plaintiff New York Marine, and defendant and counterclaim Amber Heard have met and conferred. So that's usually required before you file a motion or for a scheduling order or joint scheduling order with regard to scheduling for this matter and by and through their undersigned counsel, and hereby submit this joint scheduling report. So the reason that they met and conferred is instead of the judge just saying, hey, do these things by this time, they meet and confer so that, because each case is different, and they can inform the court of the issues in the case and decide whether or not they should have a longer time frame, shorter time frame, and obviously there are issues in this case, like they have filed these motions for. So here's Ms. Heard's position. In the prior joint scheduling report, Ms. Heard raised the question of whether this court lacks subject matter jurisdiction because there's no diversity of citizenship. Ms. Heard was not a resident of the United States at the time New York Marine filed its lawsuit and had left California intending to reside outside of the United States. That's all that's required for domicile purposes and for no diversity of citizenship purposes. However, at the time, Ms. Heard, while outside the U.S., had not yet arrived at her new permanent residence. Because subject matter jurisdiction obviously is a fundamental question that should be resolved now, Ms. Heard believes this matter should be discussed at the conference and addressed in the manner that the court deems appropriate. Ms. Heard has now filed an answer counterclaim. This consolidated action should not proceed until final resolution of the Depp v. Heard lawsuit, is what she believes and argues, which is currently pending on appeal. Ms. Heard has asserted this position as an affirmative defense in her answer, ninth affirmative defense, which we went over that Ms. Heard understands that Travelers does not oppose the request for a stay of the consolidated action, and New York Marine does not oppose a stay as to 3 of its 4 causes of action. However, Ms. Heard understands that New York Marine opposes a stay as to its first cause of action and as to claims at issue in the Travelers lawsuit. Therefore, as previously indicated, Ms. Heard will file a motion to stay or dismiss, which she has not filed either of those yet. So hopefully she files them soon. I think we'll learn more about what she says, where she has been. In addition, Ms. Heard intends to move for judgment on the pleadings as each of New York Marine's causes of actions against her. New York Marine's first, second, and fourth causes of action, which address New York Marine's duty to indemnify a judgment in the Depp lawsuit, are not ripe unless and until there's a final judgment in the Depp lawsuit. And that's up on appeal, so there has not been a final judgment yet. And so she's saying, like we went over, that it's not ripe for a decision yet. Given the appeal, there is no such final judgment. New York Marine's third cause of action, addressing New York Marine's duty to defend Ms. Heard in the Depp lawsuit, fails as a matter of law because the statute relied on does not excuse and ensure of its duty to defend. Here's New York Marine's position as it goes to personal jurisdiction over Ms. Heard. Ms. Heard has waived any objection to this court's personal jurisdiction over her by filing an answer and counterclaim in New York Marine v. Heard action. That could possibly be the case. Subject matter jurisdiction. New York Marine has on several occasions requested Ms. Heard provide any evidence supporting her contention that she was not a resident of the U.S. when it filed its complaint against her on July 8th. To date, nearly 5 months after a complaint was filed, none has been provided. So, should she have provided evidence that she was not living in the States to them? Even though, if she's saying this court has no jurisdiction over me, why would she be wanting to provide documents under this jurisdiction? So it's kind of a catch-22 in that situation. Ms. Heard's request to stay this insurance litigation, New York Marine's first cause of action, represents a pure question of law as it seeks only judgment that New York Marine has no duty to indemnify Heard for the judgment order entered on June 24th, which is the Depp case. And the issue with that is this court could make a decision on this, and then on the appeal, the court could say, we're overturning it, new trial. And pretty much this question is what they call moot, which means it's already resolved itself. And in that situation, it would resolve itself because Amber Heard wouldn't owe that money yet or at all. And so honestly, it would make total sense to say that we're holding it to see if we even need to decide this issue. New York Marine understands that Ms. Heard intends to file a motion to stay both the New York Marine v. Heard action and Travelers. New York Marine will not oppose a stay as to the second, third, and fourth causes of action, so they don't object to the other ones, but it does make sense on the first cause of action to stay it because it might not even be an issue. Now, it probably will, but however, there's no basis to stay the first cause of action in New York Marine's First Amendment complaint or to stay all or any of the Travelers' action. Depositions. On September 23rd, counsel for all parties agreed to continue the previously scheduled depositions of Sean, counsel first retained by Ms. Heard and subsequently appointed by New York Marine as retained defense counsel, and of Pamela Johnson, Travelers' claim rep, principally responsible for Ms. Heard's claim under Travelers' policy, on the condition that the depositions were moved to a certain date. So they canceled them on September 23rd with the agreement that they be moved to a certain date. So they set them for November 15th and 18th based on the agreed availability. So 2 months later, and with all the different parties of lawyers, it's extremely hard to schedule. On November 14th, in light of the objections, New York Marine agreed to continue the depositions to another date and will seek dates certain upon which those depositions may proceed if the court does not stay the Travelers' action. And to this end, ask the court require that Ms. Heard either promptly file her motion to stay or that an appropriate discovery schedule be issued, which, yeah, she should probably file that pretty quickly because New York Marine wants to get things moving, but really they should stay it. Other discovery matters. New York Marine has previously issued subpoenas for documents to other law firms. That's going to be a ton of documents, and that's going to suck to go through all of them, each of whom were retained by Ms. Heard to defend her in the Depp v. Heard action and funded by Travelers, as well as the law firm Eisner, which was retained and funded by Travelers to serve as Ms. Heard's personal counsel. So she had counsel personally as well. In the event that court ultimately decides to stay Travelers or the Heard actions, New York Marine requests that it be permitted to obtain the documents requested pursuant to those subpoenas, as production of those documents will not prejudice either Travelers or Heard, but will serve to ensure that the documents sought are maintained and available to the parties, notwithstanding any document retention policies. That is actually, they should not do that yet, because what if the appeal for the Depp v. Heard case gets overturned and you have to do a trial again? This law firm now has all of the work product of Miss Heard. That could be a big issue, especially if something happens and these documents, they can be protected under a protective order to where personnel aren't able to share it with anyone, but that's still a risk. So they should definitely stay that until the end of after the appeal is finalized. Travelers' position, they don't care about personal jurisdiction over Ms. Heard. Ms. Heard's request to stay. Ms. Heard asserts that she will be prejudiced by the consolidated insurance litigation proceeding while the Depp lawsuit is active. I will tend to agree with her. Travelers does not oppose her request for stay. Travelers understands that New York Marine will argue that it should be able to proceed with part of its case. Travelers strongly opposes a partial stay of the proceedings, especially based on what New York Marine is asking in these other discovery matters, because those are all really Travelers' attorneys that are representing Heard, and so they're going to get a bunch of information. So they're opposed to a partial stay, which they don't do partial stays that often. Usually it's a whole case that's stayed, which allows New York Marine to move forward in part as it wishes. This would be prejudicial to travelers and Ms. Heard, and it would be highly inefficient. That is true, in my opinion. It likely will drive the parties into discovery disputes, which can be avoided by a complete stay. Yep, that is true. Temporary halt. Ms. Heard has asked that the parties agree to postpone 2 scheduled depositions until the court has ruled on Ms. Heard's request. Travelers has no objections. Request for postponement. And here, if they agree to this pretrial timeline, if it's not appropriate to stay, if the court determines that it's not appropriate to stay the matter. So sets them out pretty far. And then this is just saying that it's sent to everyone. So let me know what you think in the comments and whether they should stay the case for this situation. Thanks. See you soon.